The legal sector faces a number of challenges when it comes to combating money laundering threats, but with an obligation to comply with the Proceeds of Crime Act legislation in the UK, how do legal professionals navigate these challenges? In this episode, we'll provide key insights from our panel of experts into some of these key considerations and challenges when it comes to anti-money laundering and suspicious activity reporting. The UK Financial Intelligence Unit has a national remit to analyse information on economic crime received through suspicious activity reports. This is the Financial Intelligence Podcast, brought to you by the UK FIU.
Hello, my name is Emma Jane Turner and I am the manager of the UK FIU's Reporter Engagement Team. I'm pleased to be able to welcome our panellists for today's podcast, who are joining me both in person at the SRA offices in Birmingham and virtually from Edinburgh and London. So we have Sarah Gwilliam and Colette Best from the Solicitors Regulation Authority. Sarah is the SRA's MLRO and Colette is Director of AML. We also have Graham McKenzie, Head of Anti-Money Laundering at the Law Society of Scotland, and Rick Kent, Anti-Money Laundering and Economic Crime Policy Lead at the Law Society of England and Wales. And finally, Dr. Joanne Cracknell, Director of Legal Services at WTW. Before delving into our discussion, I'm going to ask each panellist to provide a brief overview of their respective roles and the work their organisations do in the AML space. Sarah and Colette, let's start with you.
Thanks, Emma Jane. So I'm Sarah Gwilliam, the Money Laundering Reporting Officer here at the SRA, primarily responsible for submitting suspicious activity reports to the National Crime Agency, as well as delivering training on money laundering, terrorist financing and sanctions to all staff here at the organisation.
Thanks, Emma Jane. Yeah, I'm Colette Best. I'm Director of Anti-Money Laundering at the Solicitors Regulation Authority, and I work with Sarah. So we authorise and regulate around 10,000 firms, of around which 6,000 or so we supervise under the money laundering regulations. And I have three teams that I look after. I have a small AML policy team. I have an AML investigation team that investigates actual instances of money laundering or failure to comply with the regulations, and a proactive supervision team, which goes out and does inspections and desk-based reviews of firms. And I also chair LSAG, which is the Legal Sector Affinity Group, which is the main guidance producing body on anti-money laundering for the legal sector.
Thanks both. Graham, I'm going to come to you in Edinburgh now.
Yeah, hi there. So Graham McKenzie, I head up the AML team here at the Law Society of Scotland. The Law Society of Scotland are listed under Schedule 1 of the Money Laundering Regulations, responsible for the AML supervision of Scottish solicitors. We discharge our responsibilities in a number of ways, primarily by undertaking risk-based supervisory review work, thematics and inspections. We also provide a host of AML support and guidance through our website and other channels, including in regards to suspicious activity reporting. Alongside my day-to-day management of this work, I chair the UK AML Supervisors Forum, which encompasses all UK supervisors, including the FCA, the Gambling Commission, HMRC, alongside law enforcement and Treasury. Along with Colette and Rick, I'm also a member of the Legal Sector Affinity Group, which writes and issues Treasury-approved AML guidance for the legal sector. Thank you.
Excellent, thank you. And Rick, over to you.
Yeah, I'm Rick Kent. I'm the Economic Crime and Anti-Money Laundering Policy Lead. My day job is representing the Law Society England and Wales, supporting some 200,000 plus solicitors across various government, law enforcement, regulatory and supervisory forums, and currently lead on shaping policy around the anti-money laundering, sanctions and bribery and corruption, basically covering regulation and legislative compliance and best practice. This includes being a member of the Law Society's Money Laundering Task Force, which is kind of an acknowledged authority on money laundering and sanctions legislation, regulation and compliance.
Wonderful, thank you. And last but not least, Joanne.
Thanks, Emma Jane. I'm Jo Cracknell and I work within our FINEX group, the Professional Indemnity team. I work predominantly with our professional services clients, in particular law firms, and we support them in respect of all aspects of risk and compliance, and in particular understanding and assessing and managing the threats from money laundering and economic crime.
Thanks for that all, and thank you to all of you for taking the time to be with us here today. So I'm going to kick this off by talking about money laundering threats and red flags. We know the legal profession faces diverse challenges in terms of money laundering threats. So considering the variety of legal services provided by the sector, from large global firms to sole practitioners, what do you see as the key money laundering threats in your specific areas of the legal sector? And what red flags should firms and practitioners be looking out for? Sarah, what are your thoughts?
So my thoughts on this are there is no definitive list of red flags, as I think it's important to remember that every transaction or an instruction may carry different risks. I think what it is important is that firms assess the risks and properly scrutinise the due diligence material that they obtain and those inquisitive questions that they're asking their clients. However, what we see in our work from a money laundering and terrorist financing risk perspective, in terms of the red flags and the risk areas, these include aspects such as the involvement of third parties. So that could be funding or influence from third parties, the involvement of high-risk countries. So again, that could be the client, the funds, or indeed associated third parties who are linked to those countries which pose a heightened risk. Also aspects such as intermediaries being used, so that kind of corridor between you and your client. So you may not be actually engaging with a client directly, you may go through an intermediary, or indeed introducers. So people who are bringing along maybe new business to your firm may pose a risk, and again, questioning why they're bringing that business to you. Other aspects to consider: clients approaching law firms to do work that's outside their usual business activities. So, for example, large conveyancing transaction at a firm which ordinarily does very little or no conveyancing work. Other aspects: no underlying legal service or real legitimate purpose for the involvement of a law firm in a transaction. And of course, that can lead to that danger of the misuse of the client account, where you maybe have funds doing a lap of that client account and then effectively going out of that account, potentially laundered. Finally, some of the other areas we've seen: the use of complex corporate structures or trusts in transactions, funds being broken down and received or remitted in multiple transactions. So rather than remitting the whole amount, they're broken down and remitted in tranches. And finally, things like aborted or unexplained transactions. Again, potential for no rationale for a law firm to be involved. And just my final point really is remembering the risks exist with existing clients as well as those new clients coming through the door who you think you may know where their funds are coming from. You still need to manage those risks.
Thanks for that, Sarah. Some really good reminders and considerations there, absolutely. Colette, is there anything you would add from your perspective?
Yeah, I mean, absolutely agree with all of that. I suppose just to flag for firms that we supervise, we do publish a sectoral risk assessment of established and emerging anti-money laundering risks on our website. And that has a statutory basis. The firms we supervise are required to acknowledge and feed in from that into their firm-wide risk assessments. We review that quarterly and then we update it online where necessary. But I think the one thing that has very much remained stable throughout the years is the continued risk from conveyancing transactions. Certainly on the enforcement side, conveyancing is the theme that runs through a lot of them.
Graham, how about you? Would you agree with that?
Absolutely agree with that. I echo a lot of what Sarah and Colette have already said. Our own sectoral risk assessment, our Scottish sectoral risk assessment, offers more granular detail than the national risk assessment, which of course cites conveyancing, TCSP, trust and company service provision, and misuse of client account as the top three risks for the legal sector. But then not all conveyancing is high risk. Many of those listening, watching the podcast, and anyone online may well have bought or sold a house in the last few years. Not all TCSP is high risk. Some of you may know people who have been helped by a solicitor set up or administer legal arrangements for their small business, for example, or set up a trust to hold assets for their grandchildren. What makes conveyancing or TCSP or client account use higher risk, in my opinion, and this is stated in our sector risk assessment, is where there is a combination or multiple risk factors, as Sarah and Colette have just cited. I think that's really important. Not all conveyancing, not all TCSP is higher risk, but where there are multiple risk factors or there's a combination of those, that is what then elevates the risk profile.
Yeah, interesting. Really interesting. Rick, what do you think?
Yeah, of course, agree with all those points that have been covered. As demonstrated with recent developments on the sanctions front and associated risks around money laundering, today's low-risk threats can be tomorrow's high-risk threats. Avoiding terminology like red flags, which too often can be perceived as a kind of a quick fix, it's more of ensuring understanding around the story of the client and the work and the different elements, whether source of funds and wealth, identification of parties, or understanding the transactions. I would say it's definitely a thing of being more flexible and agile, critically applying the truly risk-based approach and understanding and adopting best practice. And don't fall into the trap of prescriptive solutions. Keep your mind open and always be aware of the threat.
Thanks, both. Rick, I really like what you said at the start there, that it's a good reminder that today's low-risk threats can be tomorrow's high-risk ones. So how about you, Joanne? What would you advise the professional services firms that you work with when it comes to money laundering threats and red flags?
Thanks, Emma-Jane. Yeah, again, I agree with everything that's already been said, but I think it's just sometimes going back to basics and just knowing who your client is. We're seeing where lots of issues are arising is just, it's not around complacency, but it's just that familiarity, especially around long-established clients. So it's actually really knowing who they are and also who is the beneficial owner of, if you've got the commercial clients, as well as understanding that. And also looking at, are there any changes in that long-established client's characteristics? Are they a little bit more frantic than they normally are? Are they laid back? Is their personality changed? Is there sort of a sense of urgency in getting instructions through? Are there sort of any sort of changes in their transactions? Are they a bit more erratic, or are they being a bit evasive? It's those sorts of things as well to remember. And also, again, goes back to knowing where the monies are coming from, to fund those transactions. And I think they're the sort of key areas to sort of concentrate on, I think, from my perspective.
Thanks all for those responses. Some really useful considerations there, particularly around the importance of considering those long-established client relationships and not just new clients when they come on board. So moving on now to think about suspicious activity reporting in the legal sector. The latest SARS figures published in the 2022 annual report show that the legal sector SARS make up just 0.32% of the total number of submissions. Joanne, coming back to you, do you have a view on whether this is a reasonable number of SARS for the legal sector?
Well, it's an interesting one, because what is the correct number of SARS? It's can't be that prescriptive. And again, it's very difficult to assess what is the right number with the legal profession, because it's a very different beast to the financial sector. And also every law firm is different with the size and nature and the types of transactions. So I think it's very difficult to sort of put a finger on it, or on the figure. However, I think sometimes there's so much focus on the number of SARS rather than actually on the quality of SARS, and also actually trying to understand the reasoning why a SAR's not been made as well. Because from work that I've done with law firms, and when this has come up as a question, more often than not, clients or law firms will actually decline to take on either a client or that particular instruction because something doesn't feel quite right. There's not enough information there to submit a SAR. But they would think, oh, actually, I'm not happy with this, but I'm not quite sure. So I'd rather than taking on that risk, they would decline to take that instruction on. And obviously, therefore, that information doesn't then form part of the information. So you don't know if was there something suspicious, but a gut feel isn't enough to warrant a SAR. So that's from my sort of experience. But I suppose the key thing from there is actually if law firms are declining to take instructions and making sure they're taking a record or making a record of what's been declined, was it the client, was it the nature of the transaction, and just putting a little bit of information in there about the reason why, because the other thing is with law firms, they get quite nervous about the criticism that they've received in the past for not submitting good quality SARs. So if they haven't got enough information, it's going to get declined. So it's a bit of a catch-22. But that's from my experience.
And Graham, how about from a supervisory perspective? What are your views?
Yeah, sure. So I agree with what Joanne has just said, and I might touch upon that later in the podcast. But from our perspective, so if you think about it, from over our supervised population in Scotland, last year, circa £650 million was declared in gross fees from AML relevant work, reported on our supervisory annual return. We have about 207,000 or so in the scope transactions undertaken. Common sense, therefore, may dictate that the number of SARs produced by the Scottish legal sector certainly doesn't quite make sense, or indeed might be on the low side. That said, what I'm really more focused on is improving the quality of SARs coming from the legal sector. If the whole system is premised upon getting law enforcement the information and the intelligence they need to stop and catch the bad guys, do their job, they need good quality, accurate information from regulated persons, including the legal profession, in order to do so. So that then leads back for me in terms of ensuring solicitor firms have the correct ID and verification in place, CDD processes are effective in order to improve the quality of submissions in SARs. So to me, it really is more about the quality of SARs that I'm focused on rather than the quantity of SARs.
Joanne and Graham have both referred there to the importance of quality of SARS submissions. Colette, anything further you would add?
Yeah, I mean, I think it's almost impossible to put a number on the correct number of SARs that we would expect to see. I think there are very good reasons that legal services submit fewer SARs than, say, financial services. And there's lots of challenges around legal professional privilege, fewer transactions, less automated reporting than in financial services. I do agree with Joe's point that our feeling is that oftentimes firms will decline to act at all and not take on instructions, and that might also dampen down the number of SARs. I think in those instances, as Joe has already mentioned, it'd be really nice if firms can consider, is there an information SAR that we can put in here? Because I do think the number of information SARs is looking quite small in legal services. And then finally, just to pick up on some of the points about quality that others have made, quality of SARs is something that we look at when we go out and do on-site inspections. And oftentimes we do find that SARs are of good quality, but firms miss really basic things such as glossary code. And I think some of those points are things that actually the new automated reporting system will encourage firms to make sure that they include.
Thank you. I'm really happy that you mentioned glossary codes there, some really good points across the board. And it won't surprise you to know that obviously from a UK FIU reporter engagement perspective, we are also really focused on improving the quality of SARs submitted across all sectors so that we can provide that vital intelligence to law enforcement for them to exploit in their investigations. I think we can all acknowledge the vital role quality SARs play in combating serious and organised crime. So with this in mind, what do you perceive as the most significant challenges faced by the law firms and practitioners you supervise concerning AML compliance and suspicious activity reporting? Colette, we'll come back to you first.
So let me speak briefly about some of the key themes that we see on AML compliance through our enforcement work. So this is where firms have actually had investigations conclude and enforcement action taken against them. And there are three main themes that we see in these instances. So firstly is having inadequate importance placed on having robust controls, procedures and risk assessments in place. And oftentimes this flows down from inefficient attention to detail on this at senior levels in firms. So having senior management on board is really important. Secondly, inadequate supervision and training of fee earners is really important. So training really is the golden thread that runs through all of this, that makes sure that your really good policies, procedures, controls that you've written down are actually being followed in practice. And then finally, I think systems can be a massive help in all of this. So having systems and processes that allow events to happen unchecked can be a massive problem, whereas actually you can use technology to put stops on transactions so that things can't get to the next step, for example, before customer due diligence has been completed. And then in terms of challenges in reporting, I think there are a number which are particular to legal services. So I've mentioned legal professional privilege, and I think the intersection between legal professional privilege and the SARS regime can be quite a challenging area for legal services, and one that firms do need to make sure that they're familiar with. I think another challenge can be the infrequency of reports. So oftentimes people are only making a report every few months, rather than, say, financial services that will be submitting reports constantly. So there is having to pick up a system that perhaps you've not used for a few months or perhaps a year. And then finally, I think multiple reporting can be really challenging for legal services. So by that, I mean, okay, you've submitted a suspicious activity report, but are there other reports that you still need to make in addition to that? So if there's been a serious breach of regulations, you probably need to report to your supervisor as well. If it's been a sanctions breach, do you need to report to OFSI? Chances are that yes, you probably do. Were there Companies House discrepancies? Do you need to then submit a report to Companies House? So I think the multiple nature of reporting as well is something that solicitors can at times find challenging.
Thanks for that, Colette. Some really good considerations there. So, Rick, what would you say are some of the key challenges facing law firms and practitioners?
Definitely reiterating what Colette's covered and others. One thing, though, would be understanding the context and number-wise for solicitors in England and Wales. We're looking at over 200,000 solicitors and nearly 10,000 law firms. And these cover sole practitioners to small to medium firms, to national to international firms. Given the ever-expanding legislation, regulation, and burdening expectations, the reality is one size fits all approach is, in reality, is going to disappoint. Therefore, adopting a truly risk-based approach, helping the various populations in understanding, supporting, and building is critical. I think keeping it proportionate, simple, and actually effective. And I know this is a challenge for both the supervisors, regulators, and those who are membership supporters.
Graham, how about you? What are your thoughts?
Just kind of touching back upon something that John had said, I think Colette mentioned as well, and that is the information threshold or threshold over which solicitors need to report. What do I mean by that? Well, if I put it into a scenario where a prospective client comes into the office, a solicitor's office, for a chat about a bit of business that individual or company wants to undertake, the solicitor turns down the business. There might be a myriad of reasons for that, one of which that it doesn't just quite smell right. Has he or she got enough information at that stage, having not done any customer or client due diligence at that point, for that concern to be crystallised into suspicion or reasonable cause to suspect the proceeds of crime? In many cases, solicitors are also struggling to identify the criminal property involved in terms of a DAMOSAR at least, above simply a set of concerning circumstances. But at that stage, certainly for an information side, an ISAR, they might not have enough information or undertaken enough due diligence for that concern to have crystallized into a suspicion. So I think if you talk to solicitors, that is one of the key reasons why they may not have submitted a SAR. That said, I would agree with Colette that I would like to see more focus put on the information available to solicitors at that point in which to determine whether or not actually do they have enough information to submit an ISAR, which might just be that key piece of the puzzle necessary for law enforcement to do their job.
That idea that SARs provide pieces in a puzzle is something that the UK FIU as well, we like to help reporters to understand. But I think we can all agree there's some really clear challenges for the sector there that it's important to acknowledge. So, Joanne, appreciating you're not a supervisor or a regulator, but do you have a view on the challenges in this space?
I do, Emma Jane. Yes, I do. So I think the key message here is understanding the risk. I think that's one of the challenges a lot of law firms are facing, especially because the AML landscape at the current time is just constantly evolving in response to the new threats. There's enhanced legislation. It's changed sort of twice already this month. So it's just sort of, I feel that there's an argument, there's sort of a bit of a compliance fatigue, I think, from those that are responsible. Also, the other challenge is for law firms having the resources available to them to ensure that their policies and controls and procedures are as robust as they need to be. And it's making sure that they've got the correct amount of financial and time investment. And that needs to come down from, senior management as well. So I think that they're the challenges that need to be faced, especially as we are in this current sort of economic climate and the geopolitical risks we're facing at the moment as well.
Thinking now about how the legal sector can work collaboratively to overcome these challenges and enhance the quality of SARS, what would be your key tips for legal professionals when it comes to submitting good quality SARS? Graham, I'm going to start with you.
A few kind of bullet pointed tips, if I may. First and foremost, ensuring the customer or client due diligence that you're basing your SAR information on is accurate and up to date. So it really does start with ensuring that the information that you're keeping, you're holding, you're storing, you're collecting from clients across the piece is up to date and accurate. Number two would be ensuring that on the SAR, you document the what, the where, the who, the when, the why, and the how. Okay, so covering all those basics. In a DAML SAR and a Defence Against Money Laundering SAR, ensuring you clearly identify the prohibited act that you are reporting on. And then finally, using the glossary codes available to you through the SARS portal accurately, because that really does help law enforcement direct and analyse the SAR information that you're providing.
Yeah, thanks, Graham. All really important, particularly that CDD information that firms have, which can provide such vital missing pieces of information in investigations. And our DAML team surely do love a clearly identified prohibited act. They would definitely say that. Sarah, what would your tips be?
So my advice would be the NCA sets the standards and the tone on what they expect to see in good quality SARs. And I will say that the NCA produces lots of guidance on SAR reporting. So I think my top tip would be read it. Really encourage you to read the guidance and keep up to date with the latest guidance. Also, the updated SAR reporting system, the SARS portal, which was launched early last year and which we've been using since last March, is designed to be a more structured system to help reporters on that SAR reporter journey and certainly helping to create detailed and high quality SARs. Picking out some of the sort of the key aspects from it, glossary codes. I know that there's been quite a lot of issues around glossary codes not being included on SARs. The new SAR portal, the glossary codes are embedded within the system, so you literally tick the box which one you need. And there's also a dedicated section if your report is a DAML, so that will take you off on a specific journey and lead you through what is required by the NCA. I would also say that the support information also inbuilt in the system, so again, clarifying what the questions are and any additional assistance the reporter might need. So I suppose finally, as a SAR reporter, my top tips would be keep it clear, keep it as concise as possible, although obviously they do want the devil in the detail. And critically, don't overcomplicate it. Be aware that there is probably going to be a non-legal audience reading your report across multiple law enforcement agencies. So really important to remove any jargon or acronyms, or if you're going to give an acronym, at least tell them what it is. I think those are probably my best tips on the providing law enforcement with the best quality SARs.
Great, thanks for that. And some really good tips there. And thanks for bringing up the SAR portal as well. As you say, the more structured information going in means for more structured intelligence coming out the other side for law enforcement to use. And Rick, anything that you would add?
Just reiterating the points already covered, but understanding the risks and what you should be looking for And then if being identified, submit quality SARs. And here it's not the volume of information within the SARs, a 10-page SAR of legalese that says nothing against a half-page SAR which identifies key mobile numbers, addresses, associated accounts. Be clear on what you know and critically what you don't know. The SARS portal has been a hard-fought battle. And for the next step, we'd like to see getting greater intelligence from this back to reporters on trends, emerging risks and warnings.
Yeah, absolutely. As we bring things to a close here, what support and guidance can your organisations offer to assist them in improving their suspicious activity reporting practices? We've already had a little bit of information given about what the NCA and UK FIU offers in terms of guidance. But Rick, if we can come back to you first about what is offered by the Law Society for England and Wales.
We think it's important helping to navigate the endless legislative and regulative maze and identify best practice, along with the AML guidance, which includes help on SARS reporting. It's supported by regular workshops and roundtables jointly hosted by UK FIU. We also provide various AML online training modules as well as various webinars. Critically, though, our practice advice service, we have a dedicated AML helpline, phone and email.
That all sounds wonderful. Graham, for the Scottish legal sector.
We have a wealth of information available on our website and links also into the UK FIU pages. I'd reiterate what everyone else has said. UK FIU produced some really good guidance and helpful, supportive information on their web pages as well. I would also just quickly mention the Legal Sector Affinity Group guidance. That has a specific section in it with regards to SAR reporting versus legal professional privilege, which was written by an independent academic expert on the subject, which hopefully will be of real use to solicitors in day-to-day practice. Finally, I would just mention that we're in the planning stages of thematic review of SAR submissions across the Scottish solicitor profession, working in collaboration with Emma Jane and colleagues at the UK FIU. So for Scottish solicitors and probably wider, look out for more on this in the coming year. Thanks.
Great, thanks, Graham. Colette from the SRA.
Yeah, I mean, there's loads of support and guidance out there. We have two main web pages to flag, sra.org.uk/AML, which is obviously, as the name implies, all of the AML guidance, including a link to the LSAG guidance, which I think really is the main source of guidance in this area. We've also got sra.org.uk/sanctions, where there's lots of information and advice on financial sanctions as well. We also have our ethics helpline that you can phone up with specific queries, and you can sign up to our regular alerts, SRA update and compliance news on our website. And then finally, just to flag, we have an ongoing programme of webinars, which you can sign up to watch live or you can watch back previous ones. And we also have an annual conference which takes place in the autumn, which always covers lots of information about anti-money laundering. So you can sign up to those on our website as well.
Thank you. I will also mention that obviously the Law Society of Northern Ireland also has some great support for legal practitioners in Northern Ireland as well. From a UK FIU perspective, you've heard a lot about the guidance that we provide. Please do check out the NCA website for guidance on submitting better quality SARs. But if you do have specific questions, you can reach out to the reporter engagement team on ukfiu engagement@nca.gov.uk, and one of the officers on that team will come back to you with answers to your query. So that is us for today. Thank you very much to all of our panellists for taking the time to be here today and to speak to the legal sector. Some really great insights and some really important discussion to have. So thank you very much. To keep up to date with the latest podcasts, magazines and other UK FIU guidance products, please follow the UK FIU's X or LinkedIn pages. You can also find our full collection of podcasts on Spotify and other major streaming platforms. So thank you for listening. I have been Emma Jane Turner, and this has been the UK FIU podcast.